So I'll just make a start now because we've got lots to cover today. So good morning, everyone. Thanks very much for joining our second session in our Autumn FS Academy series. For those who weren't here last week, I'm Marianne and I'm joined by my colleague Sylvia, and we are both solicitors in Burness Paul's Financial Services Regulatory team. So today we're going to deliver an introductory session into the FCA, looking at what its powers are by way of enforcing the rules and regulations which govern financial services. Just before we begin, I want to briefly mention a few housekeeping points. So as we only have 30 minutes today, unfortunately, we likely won't have time for questions, but if you do have any questions, then please don't hesitate to drop Sylvia or I an email after the session and we'd be more than happy to respond. Please keep yourselves on mute throughout, and just so you know, this session is being recorded. So I'll start by explaining the FCA's role in enforcement and the powers available to it, and then I'll pass you on to Sylvia, who's going to look at a few really interesting case studies in order to give some practical examples of how the FCA has used its powers over recent years. So to begin, I'm sure you'll all be more than familiar with the Financial Conduct Authority, or the FCA. So there are, of course, a number of other regulators within the financial sector, but as the FCA is the primary regulator, we'll focus on it today. So the FCA is the UK financial services regulator responsible for the conduct of all firms authorised under the Financial Services and Markets Act, aka FSMA. It's an independent public body funded entirely by the fees which it charges regulated firms. It's accountable to the Treasury, which is responsible for the UK's financial system, and also to Parliament. Its exact role is defined by FSMA, and under FSMA it has three operational objectives, which are to protect customers, to protect financial markets, and to promote competition within those markets. And in order to meet these objectives, the FCA has an internal enforcement division tasked with ensuring regulated firms and individuals follow the rules. So at present, the FCA is responsible for regulating around 50,000 firms in the UK. And just to give some data, as of March of this year, it's had 603 open cases of firms or individuals under investigation. The majority of these concerned suspected unauthorised business, which accounted for 35%. And other than that, the FCA's enforcement cases are primarily focused on retail conduct, insider dealing, pension advice, wholesale conduct, and financial crime. So let's now take a look at what exact powers the FCA has in order to ensure compliance. So it has a range of both investigatory and enforcement powers, which it derives from FSMA. If you want to look at these in more detail than what we can cover today, then you should refer to the FCA's enforcement guides and decision procedures and penalties manual. So I'll turn firstly to the investigatory side of things. Before the FCA takes action against a firm or individual, it will firstly need to open an investigation in order to get a full understanding of the facts so that it can decide whether to act, and if so, what kind of action might be necessary. And the FCA will start an investigation when it has reason to believe that serious misconduct might have taken place. So I'll briefly go through some of the FCA's information gathering and investigatory powers under FSMA. So under section 165 of FSMA, the FCA might require authorised firms to provide specified information or documents which it deems are reasonably required in connection with the exercise of its powers. Under sections 166 and 166A, the FCA can compel a firm to appoint a skilled person. So if, for example, it considers that a firm has breached rules which require it to collect and keep information up to date, then it might require that firm to appoint a skilled person to collect or update the information. And examples of a skilled person might include, for example, a forensic accountant or a compliance expert. And that skilled person's report might include, for example, recommendations for remedial action, and or it could form the basis of the FCA's decision to take enforcement action. And lastly, under section 167 of FSMA, the FCA can appoint an investigator in a number of different situations. So it can do so In order to conduct a general investigation into the nature, conduct, or states of a business, even if no specific breach or contravention has been identified, but it considers that there's good reason to do so. And in this case, investigators will be appointed under Section 167. If the investigation concerns a specific breach or contravention of a rule, principle, or the fitness or propriety of an individual, then the investigators will be appointed by virtue of Section 168. And as part of their investigation, investigators have the power to compel people to attend interviews and provide required information and documents. So let's turn now to the disciplinary side of things. If a firm or individual are found not to be meeting or that they have not met the standards expected of them, then again, the FCA has a wide array of powers under FSMA, which allows it to issue sanctions against them. And these powers are set out on the slide, and they include the ability for the FCA to make public statements or public censures about firms and individuals. This is essentially a public statement which would detail an individual or a firm's misconduct. The FCA can suspend firms from undertaking specific regulated activities for a period of up to 12 months. Similarly, it can suspend individuals from undertaking specific controlled functions for up to 2 years or prevent them from undertaking specific regulated activities. The FCA could vary a firm's permission on its own initiative. It could impose financial penalties, and kind of the more drastic measure would be to withdraw a firm's authorisation or prevent individuals from working in financial services completely. And out of those that I've just mentioned, the imposition of financial penalties is the most frequent sanction handed down by the FCA. And the FCA has a framework for imposing penalties on firms, which it sets out in its decision procedures and penalties manual. So normally the amount payable by a firm would reflect the seriousness of the breach and any benefit which the firm might have derived as a result of the breach. And just to give an idea of figures, in its most recent annual report, the FCA confirmed that it imposed financial penalties of over 313 million in that financial year. And it's worth just mentioning that the FCA might simply decide just to issue a private warning to a firm if it decides that the more drastic measures I've just spoke about would be inappropriate. So a private warning is a non-statutory tool often used by the FCA to let a firm know that it came close to being the subject of formal action. And it might choose this option if the matter in question is minor or where the firm has taken full or immediate remedial action. So it definitely pays to be cooperative. And just lastly, in this slide, it would be amiss not to briefly touch on the powers which the FCA has to raise actions in the civil and criminal courts. So on the civil side of things, the FCA could obtain injunctions and restitution orders, as well as being able to participate in and initiate insolvency proceedings. And then on the criminal side of things, the FCA's powers extend to being able to prosecute a number of criminal offences. Examples could be insider dealing, unauthorised business, and false claims to be authorised. The FCA also has the power to bring criminal proceedings for an offence under the payment services regulations and the money laundering regs. And it can also bring private prosecutions for offences such as fraud. Despite its criminal powers, the FCA is far more aligned with its civil and regulatory processes. It doesn't often use its criminal powers, but that being said, it has done so in recent years with notable success, and Sylvia will give an example of this shortly. So moving on to what is the last slide in my part of the webinar, I thought it'd just be helpful to end my section kind of setting out what a typical enforcement case would look like from beginning to end. So I'll go through the flowchart, which is on the slide. The first step in an enforcement action would be, as I mentioned, the appointment of investigators. So what would happen would be that the firm or individual involved would likely be sent a notice of appointment just to make them aware that investigators have been appointed. The FCA would then likely have initial discussions with the firm or the individual in order to provide a scope of the investigation, timings of key milestones, and next steps. The investigators would then carry out the investigation. So they might, as I mentioned, for example, request documents or information, and they might conduct interviews with key witnesses or persons under investigation. Then, if appropriate, the enforcement team would send a document to the farmer individual which summarises the case and any preliminary findings, and the farmer individual will then be given a chance to provide a written response. We then reach what's known as stage 1. So once a farmer individual's response has been submitted, the FCA will likely make what it deems to be a reasonable assessment of the sanction, of the appropriate sanction. And then it will give the farmer individual a period of time during which they can resolve the case. The farmer individual might choose to resolve the case in full, which means that it agrees to all issues in question, i.e. facts, liability and penalty. It might resolve the case in part, i.e. it disputes some facts and or liability and penalty, or it might contest all issues, in which case the matter is passed to the FCA's Regulatory Decision Committee. It could also refer the case straight to the upper tribunal. And at this stage, the FCA operates a discount scheme. So it gives discounts on financial penalties, suspensions, restrictions, etc. for early resolution of part or all of a case. And if the case is not settled at stage 1, then it will be submitted to the RDC, which will make a decision on behalf of the FCA and, if appropriate, issue a decision notice. The RDC, just to mention briefly, is the FCA's decision maker for contested cases. It comprises practitioners and non-practitioners from business, consumer and industry backgrounds. It's not an appeal body, but rather at the final stage of decision making for the FCA. Following the RDC's decision notice, the firm or individual has 28 days to make a referral to the upper tribunal if it chooses to do so, and the upper tribunal is the tribunal of the Tax and Chancery Chamber. It's an independent judicial body established by the Tribunal's Courts Enforcement Act, and any proceedings before it would involve a full rehearing of the case rather than an appeal. If the case is referred to the tribunal, then the tribunal will decide what action the FCA should take, and following its determination, the RDC will issue a final notice to the firm or individual concerned. So the upper tribunal has shown that while it does tend to uphold many of the regulator's decisions, it does on occasion challenge the FCA's views and findings. So hopefully that's giving you a kind of helpful overview of what exactly the FCA can do to firms or individuals who don't follow the rules, as well as giving a kind of example of how the enforcement process would typically work in practice. So I'm now going to pass you to Sylvia, who will give some meaningful examples of how the FCA has used its powers against firms and individuals in recent years.
Thanks, Marianne, and hello everyone. So we thought it would be useful to set out some examples of how the FCA has flexed its enforcement muscle in recent years. Many of you will no doubt have seen some of the headline-worthy high-value fines which the regulators have imposed against firms in the last few years. And at the end of 2021, the FCA had handed out fines to the tune of £577 million, almost 4 times the amount issued in the previous year. Just on that point, and in the interest of fairness before I turn to our case studies, I will be discussing a couple of the bigger, well-known regulated financial institutions who are more likely to be at the receiving end of the larger fines due to the sheer scale of their operations. Of course, this is all a matter of public record, and you can find details of any enforcement action taken by the FCA at the link posted on the slide there. So turning to our first case study, which is the 2021 NatWest case, which you may already be familiar with, we have chosen to include this particular example as significant due to it being the first time the FCA has used its powers to pursue a criminal prosecution for a breach of the money laundering regulations. The case involved Fowler Oldfield, a gold trading company who opened an account with NatWest in 2011. In 2016, West Yorkshire Police began an investigation into Fowler Oldfield, which NatWest assisted with. This triggered a look-back exercise by NatWest, who found a number of failings with their own systems and controls, how they had risk assessed, and ultimately failed to properly investigate the red flags in the course of the relationship with Fowler Oldfield. One obvious example was accepting bags of cash at branches without asking the proper questions to ascertain the source of funds. And by April 2014, Fowler Oldfield's account was accepting cash deposits at an average of £1.8 million a month, which cash was the proceeds of crime. NatWest self-reported these issues and took steps to remedy them. The bank also pleaded guilty to 3 counts of breaching the money laundering regulations. And NatWest was sentenced to a fine of over £264 million. It was also ordered to pay the FCA's prosecution costs, which amounted to over £4 million, and a confiscation order was issued. A victim surcharge was also payable by the bank. So as I've mentioned, the case is significant as it is the first time the FCA has used the criminal charges power available to it to prosecute a breach of the money laundering regulations. The question then follows, is this a sign of a bolder FCA when it comes to enforcement, or was this simply intended to be a warning sign to firms? It had taken 14 years for the FCA to bring its first prosecution under the regulations. However, last year, the chief executive of the FCA declared that the FCA intends to be a regulator that tests our powers to the limits. So I guess we'll just have to watch this space. A feature of the NatWest case is that no action has been taken on any of the individuals concerned, despite there being avenues by which prosecutions could have been brought, either under Section 330 of the Proceeds of Crime Act, which creates criminal liability for individuals working in regulated sectors who fail to report knowledge or suspicion of money laundering. Alternatively, a prosecution could be pursued under Regulation 47 of the regulations, which provides for individual liability of officers and partners where corporate offences are proven to have been committed with their consent or connivance, or can be attributed to their neglect. Of course, we have to remember that any criminal prosecutions would have to be proved to the criminal standard beyond a reasonable doubt, a significantly higher standard than the civil one of on the balance of probabilities. So this perhaps goes some way to explain why the FCA has taken 14 years to pursue a criminal prosecution. And it seems reasonable to deduce that the FCA would want to have robust evidence for pursuing any future prosecutions. So just looking at a couple of high-profile financial crime, AML cases before we move on. These are listed on the slides and I'll just speak to them very briefly. So HSBC, this was just 1 week after NatWest sentencing. HSBC agreed to a fine of £64 million attributed to the bank displaying weaknesses in 3 key parts of its automated processes, which were supposed to monitor and screen hundreds of millions of transactions in a month to identify possible financial crime. As well as paying the penalty, HSBC has also undertaken a large-scale remediation programme into its AML processes, which programme was supervised by the FCA. And another high-profile case, which you may have come across, is that of Credit Suisse. So Credit Suisse have received the largest fine imposed by the FCA to date, a fine which totalled over £147 million, and it was linked to the so-called tuna bond scandal in Mozambique. It was not just the FCA, but US and Swiss regulators also issued fines to Credit Suisse for the bank's failings in properly managing the risk of financial crime involving loans backed by Mozambique's tuna fishing industry. So we now move on to arguably a less exciting mode of enforcement taken by the FCA. And for this, I'll use the example of Alexander John Compliance Consulting Limited. So Alexander John Compliance had applied to the FCA seeking permissions to arrange investment deals and advise on investments as the principal for a group of appointed representatives under the appointed representatives regime. The intention was that the firms in the group would carry out the regulated activities in relation to certain securities, options and futures for certain clients, which Alexander John Compliance would oversee as the principal. And the appointed representatives regime is a useful tool which enables firms to be able to carry out regulated activities without themselves being authorised by the FCA. However, the requirement is that a principal firm will supervise and oversee the activities of the appointed rep by ensuring that effective systems and controls are in place to carry out that oversight requirement. But in May this year, the FCA refused to authorise Alexander John Compliance to carry out its business in this way. The FCA refused the permission on the basis that the firm could not demonstrate that it had the skills, experience, or the staff to oversee the intended appointed representatives. The FCA also held that Alexander John Compliance was unable to explain how its appointed reps would assess that products or services were appropriate for the end consumers. So at the heart of that refusal for permission was the FCA's intention to protect consumers from the risk of using a poorly overseen investment business. And this is why I've included this particular example. Some of you may be at firms that are appointed representatives themselves or principal firms, and I think we are going to see more intervention from the FCA where appointed reps are concerned. The FCA has very recently updated the rules around the appointed representatives regime, and this stemmed from regulator concerns around this area due to concerns around lack of proper oversight by principals and higher levels of consumer dissatisfaction where appointed representative firms were concerned. So my final example involves financial services, but it's more accurately described as enforcement for non-financial conduct or behaviour. And that case is Frensham versus the FCA. This case was ultimately heard by the upper tribunal as a result of an appeal against a decision made by the FCA. And the facts of the case were this: the FCA had proposed to ban Mr. Frensham, a financial advisor, from the financial services industry as a result of him being convicted of attempting to meet a child following sexual grooming. Mr. Frensham had committed this offence while he was an approved person and whilst on bail for a similar offence, and he was sentenced to 22 months imprisonment, which was suspended for 18 months. Mr. Frensham did not commit the offence at work. However, the FCA sought to prohibit him from working in the financial services industry on the basis that he was no longer fit and proper as he lacked integrity and good reputation. He challenged the FCA's proposed ban before the upper tribunal, claiming that the FCA had wrongly applied its fitness and propriety test and allowing irrelevant considerations to influence its judgment. He also averred that the FCA had failed to give sufficient regard to other relevant factors, including that the conduct had taken place outside the workplace and was not connected to his role as a financial advisor. But the upper tribunal upheld the FCA's decision that Mr. Frensham was not fit and proper. Interestingly, though, it was not on the basis of his criminal conviction for child grooming. In that respect, the tribunal found that the FCA had failed to forge the necessary link between Mr. Frensham's criminal offence and his professional work. However, the tribunal agreed that Mr. Frensham was not fit and proper due to his conduct after he was arrested and charged, and that he failed to notify the FCA that he had been arrested and remanded in custody, and his failure to notify the FCA of the Chartered Insurance Institute's decision not to renew his statement of professional standing and to expel him from membership, as well as his lack of remorse for his actions. Compellingly, those were the reasons that the upper tribunal concluded that the fitness and propriety test was not met. It was not on the basis of the criminal offence he had committed. So certainly an interesting decision by the upper tribunal. And I think this is something we will see more of from the FCA, the regulator imposing sanctions for non-financial conduct, especially as the regulator continues to renew its focus on promoting diversity and inclusion and advancing equality, which was most recently seen again in its 3-year strategy and business plan. So that brings us neatly onto trends and predictions. So we'll certainly, we could potentially see more instances of enforcement measures for non-financial conduct, sexual misconduct, breaches of the Equality Act. And in a similar vein to enforcement where financial crime is concerned, we may see particularly heinous misconduct being made an example of by the regulator. Another area I think we will see more enforcement in is ESG, a buzzword, particularly around sustainability disclosure requirements, where firms will be sanctioned for carrying out practices of greenwashing. And we can almost certainly expect to see more enforcement action taken as a result of the new consumer duty. The FCA has already committed to cracking down on so-called sludge practices, where firms, through their practices, make it difficult for consumers to make decisions in their best interests, where consumers find it hard to switch or cancel products, where there are obvious attempts by firms to lock in consumers to their products and services. And I think we're likely to see more fines and sanctions, potentially more criminal prosecutions even, for money laundering and financial crime breaches, which continues to be a focus area for the FCA and other regulators. Just before I bring this session to a close, I'll point you towards the link on the slide there, which takes you to the FCA's page on who can report wrongdoing or misconduct and how a person can do that. So that's the link there. The FCA also has a dedicated whistleblowing team to allow for reporting concerns confidentially, and whistleblowers will generally have protection under the law in the UK. So we're finished up a little bit early. So that's maybe a good thing. I'll let you get back to your day. But that brings us to the end of today's session. Thanks again for joining us. Please do join us again next week at the same time. We'll then be looking at financial promotions. So we look forward to seeing you then. Have a great day.